I'll have to call him.
You'll have.
Well, I tried calling him a couple of times from CMH yesterday, but
Okay, so
he had a meeting yesterday, and then he had
no, that's
personal.
fine. I just want to make sure you guys have an opportunity to do that. So
It's been nice.
you're going to get to CMH at some point. That's where you call from
Yeah.
Okay, no.
Right from the start, the judge steps in with authority, tackling a complex financial dispute involving escrow funds, rent, and eviction timelines. Tension is already building as both sides await a critical ruling. But what unfolds next will shift everything. Subscribe now for more intense courtroom drama and real legal breakdowns.
We are back on the record in the case of fixing housing 401k plan versus the wards. Counsel is present and wards are present. Folks, here's what I'm going to do, and let me just explain the beginning of one of the things I wanted to check on during my break. There may not be a remedy through the bar. The only reason I say that is because at a previous hearing, Ms. Tope had indicated she was not acting as an attorney, and therefore there was no need to put it into an IOTA. True or not, I'm just saying what was said. Taking that into account, I'm going to do it this way. I am going to award judgment to the plaintiff, the monetary part in the amount of $48,691.40. I am going to order that the $26,125 is to be paid to the plaintiff. The resulting balance, I'm going to indicate, cannot be that no collection proceedings regarding that amount can begin against the wards until May 31st. I'm picking that date to give them time to figure out if they have other remedies regarding that balance, and give them time to sort that out. Should they seek to get counsel? Should they seek to go to the bar? Whatever they may wish to do. So I'm giving that time frame. I am going to order that an order of eviction will not issue, can issue April 30th. I'm going to give additional time for to vacate the premises. You can have until, if you get out the 10th, that's fine, but they can't do anything until the 30th. I'm going to give you the month of April to get out.
Okay,
Yes.
It is what it is, but I don't know that I'll have the money to pay the lease at the beginning of April.
No, I am not going to order that the $5,500 for April be paid.
Okay, so no payments,
no payments for April. March is already in, right?
So no additional payments at the conclusion of this hearing, period.
Provided you vacate the premises by April 30th. If you're out of the premises May 1, you owe April.
Okay, so no additional lease payments, period. Unless I don't leave.
Right. If you're not out in April, then you need to pay the monthly. You have to pay April and then the subsequent May month.
Okay.
So you'll have to pay $11,000.
Okay. And the 26,125 is the number that you came up with that I paid into the court's escrow.
That is the amount we have in escrow.
Okay. And
that's
so
paid over to the plaintiff.
What we're still trying to figure out now, will my $7,500 security deposit come out of that balance? So would I pay it?
I typically do not deal in a landlord tenant proceeding because there's a whole nother section of statutes that apply to security deposits. I don't deal with nor take into account that. Since I will say this, since the amount of these amounts are rent under the Security Deposit Act, he can take that $7,500 and apply it to whatever rents due. So theoretically, it would go against us in any event.
It should go against then.
Well,
money.
ma'am, what did I just say? I said, basically, the framework of the Security Deposit Act is that I am not ruling that.
Okay.
Because I don't deal with the security deposit because you have not vacated the premises. All right. The other thing, one last thing is that the hearing, Ms. Tobe's hearing, I'm going to move that from the 17th to the 18th at 9 a.m. at a special time. I do not need the parties here currently present because I don't know that you have an interest in it. I will indicate to counsel, as I had said at the last proceeding, the amount that I had set on bond on that was to cover attorney fees that were related to the delays on that. If you would, so that you do not have to appear at that hearing, if you could submit a billing to my office that we can just hold so that I at least have that figure in mind.
I have an affidavit right here.
Fantastic.
It's current as of today. So if we don't have to show up in the next one, this should be sufficient.
All right, fantastic.
And I'll just let the, we have redacted invoices, or like seeking unredacted invoices. I highlighted the cities. You'll see.
Got it.
But if you want to see the unredacted ones, have to provide that for an in-camera.
All right. And I don't know that I'm going to need that because counsel, I think I trust you, and certainly I don't think your firm would allow you to give me something that wasn't right. So, all right. All right. Okay. Anything else?
What do I do next to, like, is this done? Do I have to,
This case is done. I've
this case is
issued,
adjourned?
it's done because I've issued the date that you can stay in the premises.
Okay.
I've also now ruled on the issue of liability with the monetary amounts that I've indicated.
Right, but I'll hear from them about that at some point.
I would imagine you
Okay, so I don't need to
Okay.
do anything. Okay,
you don't need to do anything so, Ms. Ward, so that you understand what I'm doing. I'm not allowing them to take collection efforts as to that difference till May 30th, 31st of May. The reason I'm doing that is because, as I think I had indicated from the very beginning of this case, you may have claims as against Ms. Toe.
okay,
That can come in various forms. Okay. And so I'm not suggesting one or the other. I'm just giving you an opportunity to explore your options as to how you remedy this. Because here's the cold hard reality. You're going to be out an additional whatever amount unless somebody makes that up. But counsel's right. It's not the plaintiff's obligation to do that. It's going to be whatever you decide to explore that.
okay.
Okay.
So is there going to be something signed and sent to me, or
Counsel will prepare an order. Counsel for the plaintiff will prepare an order for the courts.
I'll get a copy, and so I'll know that it's done and I never have to see you again?
Well, thanks for saying it there. But I appreciate it. Yeah.
Okay.
Yeah. You guys don't have to come back.
Awesome.
All right.
One logistical question.
Yes.
Escrow amount. We need to take it up with and clerk and what I need to do on my end to get that transfer.
We can do it one of two ways.
You ordered it released to plaintiff, so this,
But
should
it will be released to plaintiff's counsel.
For example,
correct, it goes directly to counsel.
It goes directly to counsel. So my question is, since he's here, the only one that may not be able to be paid out is this new one, right?
So all the money is technically in Celine. So Celine has to release it and our money needs to go to Celine. So
Got it.
I can
Okay, so
I can let them.
you don't need it unless you wanted it today.
I don't necessarily think we need it today, but better sooner rather than later. And my
All right.
with both courthouses to get that accomplished as soon as possible.
What I'll have my staff do is try to expedite because it's here, right? And it's got to go there.
Yes, it both places, but I can email the senior.
No, but the new payment is here.
Yes, sir.
So the new payment, we've got to get over to 4 to get into their drawer
Okay.
or whatever that is. And then it can be sent out. So what I'll have my staff do is expedite that process and then expedite the other end for the release of the check to your own.
Sure.
All right. So you don't have to do anything. We'll take care of it. If you don't see it, then call anybody but me because I don't deal with that. But all right. All right. Thank you, folks.
Thank you.
Thank you.
This is 11.
That's my 11.
Mm-hmm. Campbell is no longer in Zoom. Miss Donna.
You guys are on. Mr. Thompson. He's in Zoom.
Campbell is no longer in Zoom. Miss Haddad was in Zoom and is for an adjourn. Would you have to adjourn whatever the rest is on the record? Jesus.
So who's in?
Rania Haddad.
What about defendant?
No, when I indicated it was in person here in view, no.
Now things shift gears. After wrapping one case, a new one begins with confusion over appearances and representation. Miscommunication like this can delay justice and complicate outcomes. The judge steps in to regain control. But here's the question. Should courts be stricter when attorneys fail to properly coordinate cases like this?
But he didn't send us an appearance.
We had a limited.
We had a limited appearance, but not for trial in today's trial. Okay. Go ahead and let Miss Haddad in. All right. The court does call the case of Haverhill and Clark versus Jeffrey Thompson. Thompson, come on up to the podium. Miss Haddad, I think, is here.
Good morning, Your Honor.
Good morning. All right. State your name.
Hi, it's Jeff Thompson.
All right. This becomes a bit confusing because as I've said, as an in-person hearing, I get that was a resolution. There's a resolution to this matter. Is that correct, Mrs. Dodd?
There is, Your Honor. We have an executed conditional dismissal. There is an opposing counsel that took on this case as a limited scope representation for resolution purposes. He, I believe, was trying to log in. So I'm going to take full responsibility for the error today. I was on my way this morning. We had it on our schedule at 9 o'clock this morning, Judge, and the court's ROA reflected that. When I called the court to let them know I was going to be 10 minutes behind this morning because it's a little over an hour drive for me, I was told that it was at 11 o'clock. And so it kind of conflicted with some cases that I had. So I really do apologize for that. We do take the court's, policies very seriously. And I believe opposing counsel tried to reach out to his client. But since he is here, I guess we can, if the court would allow us to put the terms on the record, if the court would allow that.
I don't have a cell phone. I haven't had a cell phone.
What did you say, Mr.?
I don't have a cell phone. I don't have a cell phone. I haven't had a cell phone.
No. Okay. All right. I'm Mr. Dodd. I don't have. So I'm not sure of the status of Mr. Campbell vis-a-vis this case. I get what you're saying, that it was for purposes of resolution, but
It's now back in the waiting room.
he's not back in the waiting room. All right, let him in. Let's see if we can get this accomplished today. Have you talked to Mr. Campbell recently?
No, we tried to connect last night, but Alex Henry talked to me last night for a little while, but he's not.
So you
attorney.
Spoke to Alex Henry? Okay, did he explain to you that there was an agreement and that they'd be here on your behalf, or?
Told me that I had to be here to be in front of you.
Okay, he told you you had to be in front of me.
Would ask me to sign the paper.
Did he talk to you about the terms of an agreement or anything like that?
Not yet. Not
Pardon?
Not by Andrew. No.
Okay, did anybody else? Did Mr. Campbell or anybody speak to you regarding that, or?
Not yet. No.
Okay, so counsel, here's what I'm going to do. I'm gonna adjourn this out 1 week. Because well, where did he go?
No, he's still there.
Still
I'm
there? Oh,
sorry, Your Honor, I'm here. I apologize, Judge.
Not a problem. So what I'm gonna do so that everything can be explained without explaining it on the record, I'm gonna adjourn it out 1 week, and so that council can have an opportunity to speak with Mr. Thompson regarding the agreement case, all right?
Cool.
But you've indicated you don't have a cell phone?
No, no, I don't. CMH is, I have to go there well, I have to be there by 12:30, but I had to give blood this morning. So they've been trying, but because of the other thing that you
Yeah.
and I are working on, I don't know if it was official, so they couldn't do anything with me because they couldn't put me with a new case manager with Sarah Stewart.
Okay, so
So I've been
I
trying
get
the
you.
last couple of months.
So let me ask you this. If I adjourn this out a week so that you can talk to counsel, how are you gonna get through to your attorney?
I'll have to call him.
You'll have,
Well, I tried calling him a couple of times from CMH yesterday, but he had a meeting yesterday and then he had
no, that's
personal.
fine. I just want to make sure you guys have an opportunity to do that. So
It's been nice.
you're gonna get to CMH at some point. That's where you call from
Yeah.
Okay, no, that's fair. That's fair. Okay, so at some point you're gonna get to CMH, you're gonna get through to Mr. Campbell.
Mhm.
He'll explain to you what's going on, and then we can see you next week.
Okay.
How's that sound?
Okay.
All right. And counsel, if everything is done and all the documents signed, you can appear via Zoom. Although I'd like to make Mr. Dodd drive all the way out here. I'm not going to have her do that.
Judge,
Okay.
I would make the drive out there any day. It was just, I take full responsibility for the error this morning.
No, it's not a problem. It's just that Mr. Campbell, I saw the appearance. I thought it was for Mr. Henry, but I saw the appearance, but it said everything up to trial.
Mhm.
And then next thing you know, so it was a bit confusing to me, but I'm glad I got everybody here. And
Yes.
so what I'll allow everybody to appear via Zoom. If you don't, Mr. Thompson, if you don't have access to Zoom, just come down. All right, we'll be here, and then we'll do it that way.
Okay.
Fair enough, everybody?
Excellent, Judge. We really, truly appreciate it.
Thank you,
All
Judge.
right. Thank you. You take care. Take care, Mr.
Have a nice day.
Okay.
Thank you.
Thank you, Judge.
Same. So we'll just adjourn this out to 17. I don't have a pen. I don't know.
All right, that's fine.
I'm in recess. All right, 14 days.
In the end, instead of a resolution, we get a delay, an adjournment, giving time for proper communication and clarity on the agreement. It's a reminder that in court, procedure matters just as much as facts. One misstep can stall everything. Like, comment, and subscribe for more gripping courtroom stories and real legal insights.